This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about a condition precedent to recovery under a fire insurance policy where if there is no water going to the sprinkler system, there's no coverage. And failure to fulfill the protective safeguards endorsement will always defeat a fire claim. In Frankenmuth Mutual Insurance Company versus Fun FX2 Inc. and Cao Enterprises II LLC, the United States Court of Appeal for the Seventh Circuit on February 28, 2023, decided that an insurer rejected a fire claim because the named insured knew and didn't tell Frankenmuth that the sprinklers in his warehouse had no water, a material condition precedent to the policy. Fun FX2 and Cao, collectively Fun, sought insurance coverage after a warehouse fire. The relevant insurance policy issued by Frankenmuth Insurance Company provided that it does not cover losses if prior to the fire the policyholder knew of a suspension or impairment in an automatic sprinkler system, yet failed to notify Frankenmuth of the issue. Based on this policy exclusion, the district court granted summary judgment for Frankenmuth, and Fun appealed. The undisputed facts were that Fun, a costume and theatrical supply retailer that stored its inventory in a warehouse in South Bend, Indiana, owned by Cao Enterprises. Victor Cao is the sole member of Cao Enterprises and the sole stockholder of Fun. Cao purchased the warehouse in 1999. It then had a functional sprinkler system with a working supply of water. Cao replaced the sprinkler heads around 2004 and hired inspection companies for routine system testing. In 2016, an inspector from Legacy Fire Protection found no problems. When the same inspector returned on September 28, 2017, the sprinkler system had no water pressure. The inspector notified Cao, and the two called South Bend Water Works immediately. On November 15, 2017, Cao spoke with the city fire inspector to try and solve the problem. But he never heard from any waterworks personnel and did nothing else to check whether the water was in fact restored. No one ever told Cao the source of the problem, let alone that the problem was fixed. The next year, a different employee from Legacy Fire Protection performed the annual inspection in the warehouse. Cao was not present for that September 2018 inspection and was not notified of any problems. A fire destroyed the warehouse and all of its contents on July 26, 2019. Fun claimed losses exceeding $7 million. The sprinkler system did not have any water flowing to it. After the fire, the source of the problem was discovered. The city apparently had cut and capped the pipes supplying the sprinkler system in April of 2017 when the building next door was demolished. Cao was told that the worker cutting the pipe incorrectly believed that the Fun warehouse was also being demolished. Frankenmuth's policy contained an exclusion, providing that Frankenmuth, quote, will not pay for loss or damage caused by or resulting from fire if, prior to the fire, you, one, knew of any suspension or impairment in any protective safeguard listed in the schedule above, and failed to notify us of that fact, close quote. The reference schedule listed automatic sprinkler systems as protective safeguards. It was undisputed that Cao never notified the insurer after he learned in September of 2017 that the sprinkler system lacked a working water supply. It is also undisputed that no one ever told Cao before the fire that the water flow had been restored. Frankenmuth sued seeking a declaratory judgment it did not owe insurance coverage to Fun for losses from the fire. Fun asserted a counterclaim for breach of the insurance policy. The district court granted summary judgment in favor of Frankenmuth based on the policy's notice of impairment exclusion. The court found that the sprinkler system had no water flowing to it, and that Fun through Cao knew of this impairment yet failed to notify Frankenmuth. Insurance policies, when analyzed by courts like the Seventh Circuit, are generally construed using familiar contract analysis rules, and the interpretation is often a question of law. Where the policy language is unambiguous, plain meaning controls. The protective safeguards endorsement is clear and easy to apply to the facts at hand. Cao admits that he knew there was no water flowing to the sprinkler system on at least 2 occasions, the September 2017 inspection and his November 2017 communication with the city fire inspector. He admits no one ever told him that water flow had been restored. Cao also admits he never told Frankenmuth about his lack of water flow. The sprinkler system's function was to deliver water in the event of a fire. When Cao learned that there was no water in the system, he learned there was a suspension or impairment in the system and needed to report the problem to Frankenmuth, his insurer, if he wanted to keep the fire insurance in effect. Since there was no genuine factual dispute on the decisive question that Fun knew of a suspension or impairment in the sprinkler system prior to the fire and failed to report that problem to Frankenmuth, Cao had knowledge in September and November of 2017 the system had no water flowing to it, yet he never reported that fact to Frankenmuth, and as a result, there was no coverage available to Cao for the fire damage. The protective safeguards endorsement created a condition precedent to recovery of indemnity under the policy. That condition was Cao was obligated to report the fact to Frankenmuth, and he did not. Since the insured knew there was no water flowing to the sprinkler system and did not tell his insurer of the fact, the $7 million loss was not covered by the policy. Fun and Cao are not, however, without a remedy. The city cut off his water supply negligently, and he may sue to recover his loss because of its negligence. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can also subscribe to the blog, and you will receive notice 5 days a week of all my blog postings. You can also subscribe to the videos on YouTube and on rumble.com, both of which are available free. You might also consider subscribing for a small fee to my locals community and to my Substack publications, where you will receive even more information necessary to understand insurance law. Thank you for your attention.